So, the Australian Competition and Consumer Commission has launched a federal court proceeding against Google here in Australia. This could be huge news. What's going on, ladies and gentlemen? My name is Jordan C. Stewart, an Australian independent filmmaker and screenwriter and all-around shit kicker. And I have some news for everyone here today which could potentially, possibly, maybe affect YouTube. I have no idea, but I'm guessing so. But the Australian Competition and Consumer Commission, an independent governing body of the Australian government, well, from the Australian government, is alleging that Google, according to the report here on ACCC.gov.au, ACCC alleges Google misled consumers about expanded use of personal data. This was released today at the time of this recording, the 27th of July 2020, Australian Eastern Standard Time. Here it says, the Australian Competition and Consumer Commission, or ACCC, has launched federal court proceedings against Google LLC, or Google, alleging Google misled Australian consumers to obtain their consent to expand the scope of personal information that Google could collect and combine about consumers' internet activity for use by Google, including for targeted advertisements. The ACCC alleges Google misled consumers when it failed to properly inform consumers and did not gain their explicit informed consent about its move in 2016 to start combining personal information in consumers' Google accounts with information about those individuals' activities on non-Google sites that use Google technology, formerly DoubleClick technology, to display ads. This meant that data about users' non-Google activity This meant this data about users' non-Google online activity became linked to their names and other identifying information held by Google. Previously, this information had been kept separate from users' Google accounts, meaning the data was not linked to an individual user. Google then used this newly combined information to improve the commercial performance of its advertising businesses. The ACCC also alleges that Google misled consumers about a related change to its privacy policy. ACCC Chair Rod Sims has stated, "We are taking this action because we consider Google misled Australian consumers about what it planned to do with large amounts of their personal information, including internet activity on websites not connected to Google. Google significantly increased the scope of information it collected about consumers on a personally identifiable basis. This included potentially very sensitive and private information about their activities on third-party websites. It then used this information to serve up highly targeted advertisements without consumers' express informed consent. We allege that Google did not obtain explicit consent from consumers to take this step. The use of this new combined information allowed Google to increase significantly the value of its advertising products, from which it generated much higher profits. The ACCC considers that consumers effectively pay for Google services with their data, so this change introduced by Google increased the price of Google's services without consumers' knowledge," Rod Sims said. The I agree notification. The conduct is alleged to have impacted millions of Australians with Google accounts. From 28th of June 2016 until at least December 2018, Google account holders were prompted to click I agree to a pop-up notification from Google that purported to explain how it planned to combine their data and sought the consumer's consent for this. And as it says here, some new features for your Google account. We've introduced some optional features for your account, giving you more control over the data Google collects and how it's used, while allowing Google to show you more relevant ads. The notification also stated more information will be available in your Google account, making it easier for you to review and control. And Google will use this information to make ads across the web more relevant to you. Before June 2016, Google only collected and used for advertising purposes personally identifiable information about Google account users' activities on Google-owned services and apps like Google Search and YouTube. There we go. There we go. So YouTube is involved in this. Whoo! After June 2016, when consumers clicked on the I agree notification, Google began to collect and store a much wider range of personally identifiable information about the online activities of Google account holders, including their use of third-party sites and apps not owned by Google. Previously, this additional data had been stored separately from a user's Google account. Combined with the personal data stored in Google accounts, this provided Google with valuable information with which to sell even more targeted advertising, including through its Google Ad Manager and Google Marketing Platform brands. The ACCC alleges that the I agree notification was misleading because consumers could not have properly understood the changes Google was making nor how their data would be used, and so did not and could not give informed consent. Informed consent. Keep that in mind. Informed consent. We believe that many consumers, if given an informed choice, may have refused Google's permission to combine and use such a wide array of their personal information for Google's own financial benefits, Mr. Sims said, the same person. Privacy policy change. Before the 28th of June 2016, Google stated in its privacy policy that it will not combine double-click cookie information with personally identifiable information unless we have your opt-in consent. On the 28th of June, the same year, Google deleted this statement and inserted the following statement. Depending on your account settings, your activity on other sites and apps may be associated with your personal information in order to improve Google's services and the ads delivered by Google. Google's privacy policy also states, we will not reduce your rights under this privacy policy without your explicit consent, quote unquote. The ACCC alleges that Google did not in fact obtain consumers' explicit consent for this change to the privacy policy, and that Google's statement that it would not reduce consumers' rights without their explicit consent was therefore misleading. That's pretty bad. Google made a clear representation about how it would protect users' privacy. The ACCC alleges that Google made changes without obtaining the explicit consent it had promised consumers it would obtain before altering how it protected their private information, Mr. Sims said. So, this is brutal information for Google, like incredibly brutal. So if this goes forward, Google could be charged and they may be required to change its privacy policy and how it uses targeted advertisements. I know there's still more to go. This is a long media release from the ACCC. Jesus, even the ACCC v Valve Corporation wasn't this long. DoubleClick. In 2008, Google acquired DoubleClick, a supplier of ad-serving technology services to providers and advertisers. Google now supplies DoubleClick services through its Google Ad Manager and Google Marketing Platform brands, which are the leading suppliers of ad tech intermediary services. These services track users' internet activity on third-party sites that display ads through the use of DoubleClick's advertising technology. Google's acquisition of DoubleClick required approval by the competition authorities, including the US Federal Trade Commission and the European Commission. The ACCC also reviewed and cleared this transaction. The FTC and EC cleared the acquisition and in doing so considered submissions from Google that it would not be able to combine DoubleClick's data on consumers' internet activity with its own data about consumers' activity on Google services because at the time, DoubleClick's contracts with its users prevented Google from doing so. The agencies did not, however, rely on these submissions in clearing the acquisition. Before the 28th of June 2016, Google collected and stored this information on a non-personally identifiable basis as stated in its privacy policy. So, yeah, it's going through pretty much the same thing. On the date, 20th of June, it changed its privacy policy by removing the term explaining how it would treat this double-click data. Oh no. Now here we go. Here's the impact of the change in a hypothetical example. Mary has a Google account. She regularly uses the internet on both her desktop computer and mobile device, while logged into her Google account. Before 20th of June 2016, if Mary used a web browser on her desktop computer to visit non-Google websites, including websites that use double-click technology, such as news or shopping sites, or to research a health issue, Google did not save data about these activities with Mary's Google account. Similarly, if Mary used a non-Google app on her mobile device, or for example, a fitness app, Google did not save data about this activity with her Google account. While Google may have collected information about these activities, it stored this information separately from a user's Google account. After June 28, 2016, if Mary clicked agree on the notification described above, Google started saving information about Mary's activities on non-Google websites and apps that used Google/double-click technology with her Google account. For example, if Mary was researching a personal health issue on her desktop computer and visited a health website that uses Google technology to display ads, Google would have saved data about this activity with Mary's Google account. Similarly, if Mary used a fitness app on her phone, on a mobile device or phone that used Google technology to display ads, Google would have saved information about this activity with Mary's Google account. Google uses information that is stored with the consumer's Google account to show them targeted ads. Here are some images that the Australian Competition and Consumer Commission have provided. But yeah, now then so people would have seen and now some new features for your Google account, and now more specifically this one right here that you guys are going to see on screen. These are all the ones that people would have likely seen. The relevant changes to Google's privacy policy made on 28th of June 2016 are also shown below for reference. We may combine personal information from one service with information, including personal information from other Google services, for example, to make it easier to share things with people you know. They have taken out, in red and outlined, we will not combine double-click cookie information with personally identifiable information unless we have your opt-in consent. And they've replaced it with, depending on your account settings, your activity on other sites and apps may be associated with your personal information in order to improve Google services and the ads delivered by Google. This has the potential to legitimately affect YouTube, which means there may or may not be more restrictions that YouTube will have to implement on its website because Google allegedly violated another privacy act here in Australia at the federal level. This is this is huge news, and I have a feeling that this is gonna cause some controversy. So, if you guys want to keep up to date with it, head on over to the ACCC's Twitter page, and I'm pretty sure that they're gonna keep up to date with it. If there's any further information, I'll make a video about it. So yeah. Anyways, hope you all enjoyed it, enjoyed watching this, and yeah, here's to hoping that more restrictions aren't coming for YouTube, and hopefully it's just Google who's gonna get all of the brunt. But yeah, anyways, I'm Jordan C. Stewart. See you later.